Hello again, and welcome to the PM Talk Show. This is Pat Marsh, your host, and we wanted to do something a little differently. I wanted to do a commentary following our visit by attorneys Nelson Taylor and Gideon Carter, who are plaintiffs in the long-serving school desegregation case, MC Moore versus Tangipahoa Parish School Board. We wanted Attorney Taylor to come because so many versions of what is happening in the DeSeg case were being given, and we asked that he come to let the people know exactly what is going on in the case. Right now we're in the student assignment part of the plan, and as a result of that you hear a lot of things that are, much of it is not true. We place the fact that he was coming to Tangipahoa Parish in the media. We placed it on my Facebook page, and there were some people who saw it and they decided to come, black and white. We want to say that we are a friend of the court, the NAACP is, and we have been for nearly 50 years, because during the time that the late Judge Alvin Rubin made that decision, the NAACP was the most organized group in the parish of Tangipahoa Parish. And Judge Rubin decided that he wanted to make sure that there was one body that plaintiffs' attorneys could go to. Since that time, a lot of different groups have come to be, but we are able to yet have access to the court records in order to let you know exactly what motions are filed and what orders are coming out of that motion. As a result of it, there are things that are happening that many people do not know about. And as I said a moment ago, we're in the student assignment portion of that plan and the teacher assignment or employee portion of that plan. These are things that must be complied with in order to get total unitary status. Now, the school system has reached unitary status in the area of extracurricular activities and transportation, and I understand that they are in their third year, so next year, if everything has gone on and if everything proves to be what they're saying it is during their evidentiary hearing, which must be done, once things are checked out, it is at that point that they would get total unitary status in the area of transportation and extracurricular activities. On Saturday, September 26th, we were with Attorney Taylor, Attorney Carter, from 9 o'clock until a little after 11 o'clock a.m. It was a very productive meeting, but one of the questions that was asked of the attorneys, is the case over? Both attorneys said that it was not, and actually, this is the same thing the NAACP has been saying some time. It is not over, and it's a little bit of time left before it will be over, because compliance is the big part of the picture, whether or not you've done what you said you were going to do. Now, we've been back and forth with several on Facebook, but I decided to do this so that more people who do not have access to Facebook, they will know exactly what Attorney Taylor is saying. Number one, when this case was reopened, one of the things that we did for 2 years, from 2005 until the case was reopened in 2007, was that we consistently went before the board saying we don't have to go to court. Let's sit down, let's decide what you can live with, what we can live with, how we're going to do things in order to reach unitary status. Well, the opposite approach was taken by the school system in saying that the case was over, it had been over, but when we found a test case, and that case was Mr. Alden Foster, because we had not had a head football coach, and at that time it was about 40 years, and that was since forced integration. The late Judge Rubin appointed Mr. John Williams as the head football coach, and upon hearing different areas or different things about that appointment, I decided to talk to Mr. Williams myself to find out if it was true, if it was not true. As a result of it, he told me that the judge had appointed him, but he never served in the position. Mr. Carmen Moore did. He served as the head coach at Hammond High. They made Mr. Williams the athletic director, and he told me that his job was counting footballs, basketballs, whatever balls they had, keeping up with those things. So Mr. Alden Foster actually is the first official black head coach in Tangipahoa Parish Schools since forced integration. Once we got the case reopened, other things began to surface that were not being complied with from the order when the case was won in 1979. And for obvious reasons, when Judge Lamel decided to reopen the case, we proved our point then that the case had been won. However, there wasn't anything going on as far as compliance is concerned, as far as doing what they were supposed to do to get from under the court order they were under. And this is where we are right now, trying to get total compliance, unconditional compliance, so that once this case is over and the judge sees that it has been complied with, and that's when people come in and they can go into any of the classrooms, or all of them for that matter, and they cannot tell that Tangipahoa is still operating under a segregated school system. Now, on paper, there are things that really look good, but in reality, are those things really happening? And what we're finding out is that in many cases, those things are not happening, and this is why you see the push whenever something is done, or if we get a phone call from a parent, for instance, a black parent that says, my child wants to get in the pre-diploma program. This child has maintained a 4.0 all of their school life, but we have to go through different changes in order to get the child enrolled into the pre-diploma program. That's the type of thing that we fight against. A child should be able, if they meet the qualifications, to just be there. The paperwork should be at the subsequent school, but we're finding that that is not the case. Thus, it causes a problem. One of the things I put on Facebook is that the USA Department of Education versus Lincoln Parish School Systems at Monroe, they are in a desegregation case right now, and they are doing their student assignment plan as part of this deseg order. When we look at what they were doing, it is the same thing pretty much that this school system is doing. When they approached what they thought would give them unitary status, the U.S. Department of Education began to look at what you're doing, what you put on paper, what you sent to us. Let's see how what's on paper fits what's inside the walls. When they got investigators to come in to look at what's inside of the walls, the exact opposite of what was on paper was not inside the walls. In other words, they could go into classrooms and they could tell that segregation yet existed, because if you have a school and the majority of those schools, those students are white, especially in certain programs that you have, but you have a majority of blacks that are in schools and you don't find them in the program, then that creates a problem. So their judge, his name is Honorable Robert G. James. He's the U.S. District Judge for Lincoln Parish. And what he did was he signed a supplemental consent order, which meant this is what you have to do if you want to reach unitary status. This case, this particular case that I'm speaking of now, is 46 years old, way old. They complied with what Judge James told them that they needed to do. And as a result of that compliance and changing things, making it equitable, making it accessible to people who wanted to be in different programs at different schools, they have done that, and they're expecting to get unconditional unitary status granted in October of this year, sometime in October. These are the types of things that we want to see. Ladies and gentlemen, I should not have to have a parent call me, black or white, and say things like, my child is in school, they do not have access to different things. That should never be. One of the things that was discussed with a few board members a few years ago was the part about putting programs in school. One of the most common denominators that I realize is that everybody, black or white, wants their child, their children, to get a quality education. And as a result of that, we are preparing them for those things that they will have to come in contact with throughout life. I say all the time that society continues to globalize itself, and in that globalization comes competition. And if our kids are not prepared for what needs to be done, then we're going to have a problem. We're creating problems not only for them, but we're creating problems as a whole. When you look at Hammond, Hammond is the mecca of Tangipahoa Parish. When you look at Hammond, you see it sitting in the middle of everything that a business would want when they locate to an area. The only problem that businesses have with coming here are our schools. And I do realize some things are being done, but with those things that are being done, there are some that are creating problems in the process for it to be done. If a business calls me, and they do from time to time, they want to know, when will this case be over? Because we want to locate to Tangipahoa Parish. We want to come to Hammond. The only thing that I can tell them is that as soon as the school system complies with the court order, utilizing what the 14th Amendment to the Constitution of the United States says they are to do, and it's about equality, it's about dismantling disenfranchisement. No child should be disenfranchised because of the color of their skin. But what I said to someone on yesterday is that when you look at hatred, it transcends all lines. And this is the point that we're at right now. It's not about my grandchildren now getting everything, but it's about everybody's child, or everybody's grandchild getting what they need, and that is an equitable and undisenfranchised education to prepare them for what society is going to come to. And we see it happening all of the time. So our goal is to make sure that every child gets what they need, every employee gets what they need to work with. Now, there's going to be a lot of transferring of students that will be happening if the judge says, okay, you've done what you were supposed to do, and the word in his order says interim order to put into place something where all of the transfers can be done. But there's going to be some checks and balances done to make sure that these things are happening because of the history of this school system. And while you have people, black and white, that are making attempts to work together, the one thing that you have to realize is that you have to be sure that you're doing it according to what 14th Amendment, according to what the federal judge is saying that you have to do, according to whether or not the plaintiff's attorneys do it. Now, it's been said, there have been motions that were filed, and it was said that the plaintiffs agreed. The plaintiffs, according to Attorney Taylor, and he reemphasized this, are the class of black children and their parents. Unless there is an appointment of a body that would represent that voice, then you can't talk to one or two people and they say this is what everybody wants, because that's not how it goes. You have to look at all the facts. You have to present to plaintiff's attorneys your reasons for objecting, your reasons for accepting. And if they agree, if Attorney Taylor agrees as the lead attorney, then that's what it will be. If not, then they go back to the judge, well, this argument is being made or that argument is being made. The problem with, well, not problem, it's not a problem for us because we want the right thing to be done. We want to work together to make sure that things are done so that when all of this is over, we won't have a repeat of this particular thing ever again, because money that's spent is being taken from children that really, really need it, and we'll get into some of those things in a few minutes. But when you look at this group here, that group there, and nothing of effect is coming out of it, even though a couple of our plaintiff's attorneys signed off on some things, we were very upset about it because you didn't have all of the information that you needed not to sign off on it or to work further with it. So now you have a situation where we were having to bring in Attorney Taylor just to get he and Attorney Gideon Carter to let the people know the case is not over. The student assignment plan has not been fully approved by the judge. He gave an interim order, which means let's see what you're going to do with what you're telling me you're going to do. But if there are issues with that interim order, then it's up to us to prove what those issues are, and we have done that. So we wait to see what's going to happen whenever they have an evidentiary hearing before this is put into place. When you look at a child, and this is difficult for me, it's very difficult for me because when we go to advocate for children in the school system whose parents come to us and say, my child is not getting what they're supposed to get, what can you do to help? When we go and we find out many times that a lot of those things are true, it's difficult for me because if a child says, Miss Pat, why am I treated differently? Why can't I get this? Why can't I get that? And I don't have an answer. It is painful to see the pain in the kids' eyes because you see a sincere desire of kids wanting to do but not given the same ability to do as is given to other students. I reference a case where I visited Crystal Street one day, and to me Crystal Street was just a place. You can't just put kids out on the street. You have to do something to help them, either homeschooling or send them to a facility for whatever infractions that they did. Some of the infractions could have been settled, we feel, at the principal's level. However, they were not. But this particular day, I was sitting by a child, and he had a lot of pain in his face. And I was hesitant to ask him anything because I didn't know how he was going to react, but I did anyway. And when I did, I asked him, what do you want to do when you graduate from high school? And he told me, I won't. And I said, why? He said, it's no use. I go, what are you talking about? He said, because I made some dumb mistakes and nobody's going to help me. And I said, well, he was holding a pencil, and I said, what is the purpose of an eraser on a pencil? He said, to erase mistakes. And I said, now, if someone helps you to get back to where you need to be, would you do it? And he said, yes, ma'am. At that time, the former desegregation implementation officer was there, Mr. Jackson, and he came out of the principal's office, and I said, well, yeah, you're the man I need to see. Lionel told me I have 2 minutes, and I said, I don't want but 10 of them. We have a child with a problem. Let's go in here and find out what's going on and how we can help that child. Well, we did, and when he pulled the child's record and saw what the infraction was, and I did not ask him because I didn't have permission to act on the child's behalf as far as knowing what he had done to get him where he was. But I did have the authority to see if I could help him or if the NAAC could help him to reach whatever his goals were, and we did that. He said, what this child is here for, it's the equivalent of throwing a spitball. He shouldn't even be here. I talked to Miss Dunn, who was the principal at the time, and they were getting ready for summer school, and I asked her, I said, Miss Dunn, I said, is it possible for this child to come to summer school? And ladies and gentlemen, he was 2 years behind, but I knew he had the wherewithal to do what he needed to do if given the opportunity. And his mom, his grandmother, they were all willing to help. His aunties, they were really willing to help to get him where he needed to go. His problem was he had a speech impediment. and we call it tied tongue. You could barely understand what he was saying. Was in speech therapy, but when he made it to the 9th grade, they took him out. And there was a reaction from, sometimes kids can be cruel. When he talked, they would laugh at him. So he completely shut that out and began to do things that, I guess, reacting to what his unacceptance was. Well, he went to summer school, and he completed 2 years of learning in 4 months. And that was amazing. The next thing we needed to do was to get him into a school where he could get what he needed on a daily basis. He is at Laranja High now. He is an honor roll student. He's playing football. He is a model student. His brother is there playing football with him, and his sister is there, and they are doing fine. These are the types of success stories that you don't hear a lot of, but we want you to know that we are out there working, and we do the same for white kids as well. White parents who call us that need help, we get them the help. And we make sure that everything is okay with them. It's continuing to be okay because we call, we check on them, and is there anything else we can do, just let us know. And sometimes they do, and sometimes there isn't a need to call back because the child is placed on a straight track and they're doing so much better. We would like to see this case over because it has an effect of making you tired at times. But we're not giving up for this reason. It's all about our children. Tangipahoa Parish, I envision being the parish that was under a 50-year-old desegregation order and coming out of it being the best school system in the United States of America. I have that belief. I've prayed, I've asked God to give that to the children of this parish because we owe it to them. My final comment is this. Parents, I had to do this myself with my own daughter. A lot of times you have children who are valedictorians, black, and those honors have been taken away from it. We worked these cases for years, many years, and as I was working them, I began to watch what was going on, and I knew I had a gifted daughter. And I wanted to make sure that that status would not be taken away from her when she was ready to graduate. So parents, if you have gifted children, their report cards, their papers, their progress report, everything that comes from the school, get a folder and put it in it. I had to do that, and I got a call from, and I met with the principal, and I told Miss Lucille Morris, I said, if what we have been working on to help other kids happens to my child, you see it happening, I want you to let me know. And she did. They began to shave points away in order that my daughter would not get the valedictorian honor. And as a result of it, Ms. Morris called me one day at work and she said, they're taking it away from her. And I said, well, you take this message back. You tell them that they do what they're going to do, and when they're finished, I'm going to do what I have to do, because everything that she's ever done in the school system since the 8th grade, I have all of those records. Well, I don't know if it provoked fear. I don't know, and it's really not important. But what I do know is that she gained that status and she marched them in at Southeastern, and today she is a licensed attorney, taking the bar for the first time and passing it, getting hired at a law firm before she graduated from law school in New Orleans. So these are the types of success stories that we want to have. We want to see our kids become doctors, lawyers, and whatever, but we especially want our kids who will not go to college have some type of vocational skill that upon graduation they can go directly to work. They don't have to wait until they graduate to get into VOTEC school. If they do this, their choice. But if we put programs of substance like you have STEM, those are the jobs that are here now. And if the kids, engineering, math, whatever it is, let's prepare our kids to be prepared, because we have 75%, ladies and gentlemen, that are not going to go to college, and they have to be prepared. All of our kids do not have to go to jail. All of our kids do not have to go and get on drugs to sustain themselves or make a living. And my thing is, I don't want to see any of them perish, any kids perish, but I want to see my parish, my home, successful with our kids being successful. One of the things that you want to do is get with your board members and ask them about the numbers of people that are going to be transferred to different schools next year. It would also be a good idea if you would go and ask your board members to let you see the raw numbers that they have gotten that shows where our schools are via school performance scores. And I'm told that they're not good at all. And I'm hurt that they're not, but it's not something that we can't come to do and come up with solutions that can make it better for the next year. Also, if you're interested in looking at the document, the order that came out of the USA Department of Education versus Lincoln Parish School Board at Monroe, that document number is 151. The the lawsuit number is 66-12071. 66-12071. And our board members have access to Pacer. They can pull it up, give you a copy of it, you can read it, and there you can see what needs to be done. And maybe you can encourage your board members. We want to not necessarily imitate what they're doing, but look at what has to be done in order to get unitary status. Thank you for allowing me the time to speak to you about what's really going on. We appreciate attorneys Taylor and Carter coming to talk to the people to let you know what's going on, what has to be done in this case. This is Pat Marsh, your host, saying that we appreciate your continuing to join the PM Talk Show. We ask that you continue to do so. Join in again. Remember that knowledge is powerful and it does matter. Thank you. Have a blessed week.